Getting our steps in.
As long as we get it sorted out.
Getting our steps in. Sorry. Getting our steps in.
Yes, if the parties can place themselves on record.
On behalf of the NPA, together with my colleagues, Advocate Koopman and Advocate Mvandava. Judge, if I can just, sorry my lady, if I can just draw to your attention that there are parties who are not represented in this matter at this hearing. In respect of Mr. Williamson, Mr. Engelbrecht and Mr. Erasmus, Deploy Inc. attorneys are on record, that is Mr. Miller on their behalf, and he has indicated that he is unfortunately unable to attend today. In respect of Mr. De Beer, we have received correspondence from Mr. Albertine from DKVG attorneys. Mr. Barnard, Dr. Barnard is represented by Ward Brink Inc. attorneys, Ron Ward in that matter, and Mr. Baron Duplessis, who appears in person. They have all asked to be excused in respect of today's hearing.
Thank you, Ms. Bosman. That has been noted.
As the court pleases. Milady, I appear on behalf of the families. I'll set out which ones shortly. I appear with Advocate Snyman and Suleiman, instructed by Cliff Decker Hofmeyer. Milady, we represent the immediate families of the Cradock 4. These include the following family members of the late Fort Kalata: Nomonde Kalata, the widow; Lakanya Kalata, his son; Dorothy Kalata, his daughter. In respect of the late Sparrow Mkonta, we represent Lonwabe Mkonta, the son of the late Sparrow Mkonta. In respect of Matthew Goniwe, we represent Nyamtsimo Goniwe, the son of the late Matthew. And in respect of the late Kelo Mshlali, we represent Nombuselo Mshlali, the widow.
Thank you, Mr. Vanya.
Perhaps it falls upon me to place myself on the record. Thank you, my lady. My name is Tameka Mkatobi. I am with Ms. Poison and Ms. Vitalis. We represent the Cradock community. We also represent Mr. Ulelo Oniwe. We also have for the Lord Oniwe family. Thank you.
My lady, although not parties to the proceedings before you, you will recall that you issued an order on the 12th of August against two organs of state, namely the South African Civil Service and the South African National Defence Force. I represent those two parties in the rescission application that was brought on their behalf in respect of that order.
Thank you, Mr. Carter.
May it please the court, my lady, NMW van Sail SC from the Pretoria Bar. I represent General Christoffel Peer from the Westhuizen. My instructing attorney is Mr. Rowan Lewis. He is also present from Jacobs Lewis Fouché Attorneys Inc. in Pretoria. And as per the arrangement at the last case management meeting that the witnesses be excused, my client is not present, but we will be present.
Thank you, Mr. Counsel.
As it pleases the court, my lady, Fisaki L, on behalf of Eugene de Kok, my lady, from the firm LBB Attorneys in Pretoria. As it pleases the court.
Thank you, Mr. Fisaki.
Milady, before we proceed, unfortunately my list was incomplete. I left out somebody important. We also represent Tamani Kalata, the other daughter of Fort Kalata.
Thank you. Mr. Bosman, Mr. Postman, are you intending to address the court?
Yes, thank you.
All right. Before I call upon you to do so, may I just indicate that today, being the 2nd of September, was scheduled for the start of the reopened inquest into the deaths of Messiahs Fort Kalata, Matthew Goniwe, Sicelo Mhlauli, and Sparrow Mkondo. It has, however, become clear to all that the inquest will not be proceeding today. This is due to issues relating to the payment of legal costs for some of the parties, to which I will, however, give an opportunity to the respective parties to address the court, starting off with the representative for the National Prosecuting Authority. Mr. Coachman.
Thank you, my lady. And
Thank you for dealing with the issues or the reasons for the postponement of the matter, because there's one of the issues that I was going to just briefly touch on, because our difficulty has been that we sometimes have a narrative out there that
I thought you said Ms. Bosman would be addressing the
yes,
proceedings.
yeah, that's why I apologize.
All
I
right.
said that I was not going to say anything, but I was in fact instructed. Let me rather leave it at that. I was instructed to address the court, but it will be very short. My lady, and as I said, thank you very much for just setting the record straight, because it's important that we make it clear and that it is so understood by everybody else that the state is in fact ready to proceed. And that has been made clear some time ago. The point is that what we had to do, and it's been accepted, that we need to give everyone else the opportunity to be properly represented before this court, because these are indeed heavy matters. And my lady, it is important that we remind ourselves why we are here. And I'm sure most of us in this court, in fact, know why we're here, and probably out there in the world as well. But I don't think it'll suffice to just leave it at that. One should perhaps restate it over and over and over again, that it is important for South Africa as a whole, but not only South Africa, the world out there, and especially our youngsters, to understand what had happened, to understand what had happened to our leaders. Because these deceased, we call them today deceased, and that's what they always explain, that you go into, before you die, you're still Yannick Goldman, and at your death you're deceased, or you're a body. They were in fact all part of our communities, my lady. They had professions and they had families. And they played leading roles in the struggle against apartheid. And they got us where we are today. We were not going to, and we were going to make, in fact, a proper opening address at the commencement of the proceedings. But perhaps one should just briefly say that we know that these four activists were killed on the night of the 27th of June 1985 on the national road leading to Cradock and near Quebec. We know that they were unaware that they had been targeted for assassination. We know that they were kidnapped by special branch members of the security police, and never seen alive. But we know that they'd been killed that same evening. We also know that the mutilated and charred bodies of the deceased, which were found several days later, were left scattered at different isolated locations in the vicinity of Quebec. On the date of their funeral, a national state of emergency was declared and remained in place for years. The role of apartheid's top secret hit squad remained a matter of speculation for years, with persistent denials of involvement of the special branch and the government of the day throughout the first and second inquest. We know the emergence of the signal, which never surfaced during the first inquest, called for the permanent removal of Matthew Goniwe, Mbulela Goniwe, and Fort Kalata from the community. Lady, I do not want to take much of your time and everybody else's time. Suffice to say that we know that there were then two subsequent inquests that couldn't give clear answers to their deaths. We know that, for instance, on 21 February 1989, the New Brighton Regional Court, Magistrate E. De Beer, found that the deceased had been killed, and I quote, by a person or persons or group of persons unknown, close quote. We know that thereafter followed, and that was with the emergence of the signal, the Zietsman inquest, which was held in this court, presided over by the former Judge President Zietsman, and eminent members of this legal profession had been part thereof. And I recall retired Judge Clive Pleskett, people called Judge Mohammed Nefsa, and eminent counsel George Bezos. And I also remember our present judge at the Supreme Court of Appeal, Glenn Forson, who were also part of it. And then I just want to quote just a few, about 2 sentences, what the judge president had said. And I quote, "There is no evidence to prove that the recommendation and signal was adopted and carried out." Then he says there is no evidence to prove that the person or persons who murdered Matthew Goniwe and the others knew of the signal or its content. Evidence to link the signal with the murders is lacking, and the setup of the National Security Management System does not in itself justify the assumptions and inferences I have been urged to make. What the judge eventually did find, and that was a point that had been made out by our former late Chief Justice Arthur Cheskelson, and already in the regional court inquest, that the persons who had killed the deceased must have been members of the security forces. The magistrate did not go that far. As Zietsman did in fact then find that they must have been members of the security forces. It is only during the TRC proceedings that evidence then emerged as to who the actual killers had been. And we know who they are. But yet what our point is, what we're going to do throughout the proceedings, is to point out that there were others involved. And that those others were in fact the decision makers. And that is why we are here today.
Thank you. Thank you very much, Mr. Coltman. Although where he didn't and could not have placed himself on record, the Director of Public Prosecutions is also present in court today. Thank you. Ms. Devani.
As the court pleases. My lady, we have prepared a short address. With the leave of the court, I'd like to hand up a copy for your ladyship.
Thank you. Thank you.
My lady, the families of the Cradock 4 have been waiting 39 years for truth, justice and closure. The 27th of June 1985 next year will be the 40th anniversary of the gruesome murders of the Cradock 4. They've been dealt yet another bitter blow with this postponement. And it's really important, my lady, that we place this postponement of this reopened inquest in its proper context. Lady, I did not expect to address the substance of the facts today, but since my learned friend for the state has placed the 7 June 1985 signal into the record, and that the Zietsman inquest wasn't able to get to the bottom of that particular signal. We simply place on record that a signal was sent by the military stationed in Port Elizabeth, as was known at that time, on the 7th of June to the State Security Council, calling for the urgent permanent removal of the individuals in question. And mere weeks later, on the 27th of June, they were in fact permanently removed from society. And of course, when the inquest is heard, we will elaborate on that very powerful, compelling circumstantial evidence. Milady, during August of last year, 2023, it was agreed between the NPA and the families that the inquest should be reopened, making it the third inquest into the deaths. The families had pushed very hard for a prosecution against the remaining suspects. But with the death of Hermanus Barend du Plessis, the former head of Security Branch's Black Affairs Unit in Port Elizabeth, I believe on the 23rd of May last year, he was in fact the last person against whom there was a prima facie case. So the families reluctantly had to accept that an inquest should proceed. The Minister of Justice announced on the 4th of January 2024 that the inquest would be reopened. On the 7th of February 2024, the family's lawyers, Cliff Decker-Hofmeyer, sent the NPA a proposed schedule for the hearing, setting out the witnesses who were needed, together with time estimates for their testimony. This schedule was agreed to at a meeting between the family representatives and the NPA on the 22nd of February earlier this year. On 27 February, the family's lawyers proposed hearing dates, namely the first 3 weeks of September. In fact, starting today, these were proposed to the NPA. The NPA agreed to these dates on the 4th of March. And then, milady, we didn't hear much further thereafter. So on the 9th of July, we addressed urgent letters to the NPA and yourself as the presiding judge, expressing alarm that the inquest was in the danger of collapse. And regrettably, milady, this concern proved to be prescient, because all efforts attempted thereafter to salvage this inquest has come to naught. address was captured, so I really. Okay.
Do you want to check your notes in case? Check mine. No, they wouldn't have been me. I'm at the Durban bar. Most of the time it would have been either Albert and Tiffany Murray and Mr. Ethan. Oh, yeah, it wouldn't have been me. Oh, yeah. But it's nice to meet you.
Ja.
I know. Atsakona. Diva kusithiwa uyalwa nabelungu bakho. Kuthiwa no babemfakile kubhiyi bayamkhupha ngoku.
Even if it's one copy, because this thing is moving, he doesn't want to send reply, look and says, I think the way they are scanned.
Do you have the source file with you?
No, I just said,
I can see why it's
Did he send you the mail? I'm going to check with you.
I've got it. Thank you so much. I got it. Nicolas, he's the one who said that.
That mess was never next to me. No one else was left with a pen right here.
Ek het nou net met Jan gepraat so want hy is so baie iemand is met maar
As the court pleases. The lady, I believe we had gotten up to the point where in early July, on the instructions of the families, we addressed urgent letters to the NPA expressing alarm that this inquest was in danger of collapse. And as mentioned, this concern proved to be prescient because all efforts we made thereafter to salvage the inquest has come to naught. Now, the NPA has indicated in a letter that their hands were tied because they had not received final confirmation of the dates of the inquest, and accordingly they couldn't take preparatory steps such as the issuing of subpoenas. Milady, with respect, we don't find this an acceptable justification not to take preparatory steps. The NPA is dominus litis in this matter, and this court sits in the same division in which they are based, and there is no reason why the NPA could not have extracted confirmation of the dates, even if it meant knocking on doors or camping in the registrar's office. According to the legal representatives of the former police and army witnesses, they were only advised of the reopened inquest and the hearing dates during June of this year, and they've complained that this was way too late notice for them to organise funding for their legal costs with the state attorney, as there is a complicated paper trail required, which includes seeking approval from various departments, notably the police and defence. And as it turns out, this was the primary reason for the collapse of the inquest. As it turns out, it appears that the witnesses were only subpoenaed during the month of August, a mere few weeks before the inquest was due to start. If I may turn to the impact of the postponement on the families. Milady, the postponement has particularly serious consequences for the families and the wider community. In the first place, the hopes of the family for some closure after more than 39 years of waiting has been dashed yet again. They have endured decades of cover-ups, obfuscation, and idleness on the part of the authorities, all their efforts to see justice done in a criminal court have come to naught. Now, when a reopened inquest was finally going to happen, they have been let down again, and needlessly so. Secondly, my lady, we are gravely concerned that the postponement may very well result in a grave miscarriage of justice. In our investigations of the Cradock 4 case, we have identified some 49 persons who were associated in one form or another with the crimes committed against the Cradock 4. Virtually all of them have died. All 6 members of the police hit squad who murdered the Cradock 4 have died. They were Major Johan Martin Saki van Sale, Lieutenant Eric Alexander Taylor, Sergeant Gehadus Jacobus Lotz, Warrant Officer Mbala Glenn Mguduka, Sergeant Amos Temba Faku, Walila Shepherd Sakati. Most of the masterminds who planned or facilitated the operation against the Cradock 4 have also died. These include Colonel Harold Snyman, Colonel Lawrence du Plessis, Major General Nicolaas Jacobus Janse van Rensburg, General Pieter Johannes Jacobus Jannie Geldenhuis, Major General Frederick Johannes van Rensburg, Lieutenant Jacob Jan Hendrik Jaap van Jaarsveld. Lady, most of the members who sat on the notorious State Security Council between 1984 and 1985 have died. Of the 27 persons who attended one or both State Security Council meetings on the 19th of March 1984 and the 10th of June 1985, at least 14 have died. And just for context, my lady, on the 19th of March 1984, the then Minister of Black Affairs, Baron du Plessis, called for the removal of the teachers, the troublesome teachers in Cradock. And on the 10th of June 1985, then Deputy Minister of Police Adriaan Vlok persuaded the State Security Council to allow the joint management committees at a local level to act on their own. So of the 27 persons we've identified who attended those meetings, we've been able to establish that at least 14 have died, and possibly more by now. Since the families launched a civil application to compel the NPA and SAPS to finalize their investigations, that application, my lady, was brought in July of 2021. Several persons of interest have died. They include Eric Winter, former Cradock Security Branch Commander, F.W. de Klerk, former President of South Africa, Johannes Velder van der Merwe, former South African Police Commissioner, Adriaan Vlok, former Minister of Police, Baron du Plessis, former Minister of Black Education, Hermanus Baron du Plessis, former head of the Security Branch's Black Affairs Unit in Port Elizabeth, who died on the 16th of May 2023. Lady, the primary reason behind this monumental failure of justice has been the political interference that effectively killed off the bulk of cases referred by the TRC to the NPA. My lady, those behind the machinations knew that this would be the outcome. They knew that countless people, countless perpetrators would escape justice. My lady, those behind the obstruction must be held to account. Turning to the surviving persons of interest, my lady, they're all in the twilight of their lives. Gerrit Nicolaas Erasmus, former Lieutenant General and head of the Security Branch in the early 1980s in Port Elizabeth, is 88 years old. Itzhak Johannes Krappies Engelbrecht, former Major General and head of the SAPS Counterintelligence Department, is 84 years old. Christoffel Pierre Joffel van der Westhuizen, former Lieutenant General in the South African Defence Force and former Officer Commanding Eastern Province Command, is 82 years old. Craig Michael Williamson, former head of Security Branch Intelligence, is 75 years old. Lucas Daniel Neil Barner, former director of the National Intelligence Service is 75 years old. My lady, given the advanced ages of these individuals, it's highly likely that most or some will not be available to testify when this inquest is eventually held. And this will be devastating for the families. They will yet again be denied the opportunity to hear from those associated with the Cradock 4 case, and this would amount to yet another unforgivable miscarriage of justice. In conclusion, my lady, should the question of legal costs for the former state officials and Imbelela Ganiwe, the nephew of Matthew Ganiwe, drag on through litigation in multiple courts, it will effectively kill off this inquest. My lady, we place on record that it is iniquitous that the state supplies generous legal support to the former officials while not supplying any support to the families.
Which has not yet been done in this case in any event.
It has not yet been done in this case, and we hope it will, but we place on record that it is an iniquitous distinction, and we do support the demand of the Cradock 4 community and Imbelela Ganiwe in their quest to be supported to appear properly in this inquest. My lady, a toxic mix of political interference, incompetence and indifference has shut down virtually all of the cases referred by the Truth Commission to the NPA over the last 2 decades. There are only a handful of cases that can be taken forward, and the clock is ticking in all of them. Suspects, witnesses, family members are in the twilight of their lives, and they are dying on a regular basis. Yet, my lady, it is with regret that I must say we see little sense of urgency on the part of the authorities. Although there have been some 5 reopened inquests dealing with apartheid-era cases since 2017, albeit in other divisions, there appears to be little or no learning from these experiences, with no lessons or best practices being passed on to new teams. My lady, it is high time that the NPA, State Attorney and relevant departments, including the SAPS and SNDF, came together to work out a seamless approach to the question of legal costs to avoid this wholly unnecessary fiasco from happening again. My lady, we have proposed that in the application to be brought by Sakele Incorporated on behalf of Imbelela Ganiwe and the Cradock 4 community, that a high-level meeting be called, because at the end of the day, litigation is not the answer. If the litigation is going to be pursued, and if the state parties are going to oppose, it will not be resolved by June of next year. One or other party may end up taking it to an appeal court, indeed all the way to the Constitutional Court, in which case the proposed dates for June next year simply will not happen. And my lady, this would be fundamentally unacceptable for the immediate families. As I mentioned, 27th of June 1985 is the 40th anniversary of the murder of the Cradock 4. The families will not accept, I repeat, will not accept a further postponement in this matter. The inquest must and should be held before the 40th anniversary and to our minds concluded before the 27th of June 2025. My lady, we have nothing further to add.
Mr. Ngubaitori?
And then I'm not sure if the NPA wishes
to reply,
to respond, because some of the points made are against it.
That you were going to respond after the other parties had made their representations.
Okay, then you can carry on then, Mr. Ngubaitori.
Thank you, my lady. My lady, what happens to a community when its leaders are brutally uprooted? And how should the democratic state respond to such murders? What should it do to address the psychological, the spiritual, the material, the social, and the economic consequences of a brutal uprooting of its leaders? Does the community splinter? Does it stop being a community? Perhaps as a first step, what we owe the Cradock community is the truth. And therefore this inquest matters because of this function of truth-telling. Previous inquests have singularly and regrettably failed in the duty of truth-telling. Now today the community is here, the court is full. Why is the community here? It wants to know what happened. Why do they need to know what happened? Apart from anything else, they want closure. But closure is not possible without disclosure. So the Cradock 4 were not islands. A teacher in a black community is a person of immense influence, stature, and importance. Matthew Goniwe was an intrinsic part of the community. And so were his colleagues. The evidence which shall be laid out will bear full testimony to the members of the community who were touched by the degrading killing. But they had also been touched by the humanity, the warmth, the bravery, and the leadership of the Goniwe brothers, the Mkhonto family, the Chalata family. Only through these testimonies, we shall say, the testimonies of the community, can the true scale of the loss, sorry, I forgot the Mhlauli family. Only through the testimonies of the family, we shall say, can the true scale of the impact of the killing of the Cradock 4 be understood. But closer home, we can also understand why they were targeted. What the evidence will reveal was a planned assassination by agents of the apartheid state. Mr. Mulelo Goniwe is also my client. His name will appear from the record as a person who was also targeted for assassination. No doubt he's not the only one. There are many others. Some of them are in court today. In this sense, Mr. Goniwe is a direct victim of the planned assassination in his case and the successful assassination in Matthew's case. He is therefore a central player in this inquest. His family, the Goniwe family, is also the family of Matthew Goniwe. It is also the family of Nyaniso Goniwe. There is really no separation. They are one thing. And so we will say to your ladyship that the death of the Cradock 4 has devastated the nuclear family, the broader family, and the entire community. This is why we ask at the beginning, what is the obligation of the state in cases like this? What does a democratic state do to atone for the brutal murder of the most promising, the leading lights in black communities? At the very least, the state owes us a duty to assist in the function of truth-telling. That very list must include funding. We have asked the legal aid for funding. They have said no, for reasons which we shall say are incompatible with the obligations of the state under the Constitution. Because if the state will not pay in order for us to know the full scale of the brutality of the apartheid regime, who else will? My clients are not in the position of the other families. But that distinction is without any difference. It is by happenstance that there is a good Samaritan willing to pay for some families. But it should not be a South African expectation that when people go to these inquests, the government will play dead and play silent. And it's for this reason that we will say urgency is important, but it must be balanced with other requirements, which is that the community, the family of the Goniwes, Mr. Mbulelo Goniwe, are entitled to full state support and full legal representation support. If that is to be extended to other players, so be it. But it cannot be excluded on the basis of expedience. We will not burden your ladyship now with the actual application, but we will inform your ladyship that this morning an application was brought to say that it is incompatible with the South African Constitution, that the Cradock community is in court, but it has no money. And therefore, we will ask your ladyship to make an order compelling the state to cover the legal fees of the community, of Mr. Mbulelo Goniwe, and of the Goniwe family. Hopefully, this will not be necessary. Hopefully, sense will prevail. And hopefully, the meeting that Mr. Vani proposes will indeed take place. And we hope all of this can be solved indeed before the commencement of the inquest in June 2025. Thank you, my lady.
I would like to address the court before I give the prosecution an opportunity to reply or respond.
Nothing from our side, thank you.
Already. Yes, Ms. Bosman.
Lady, there are certain aspects which have been raised by Afghani which we just think need to be clarified. It's the entire speech revolved around the fact that the NPA has been sitting on its laurels and not attending to the necessary. The civil action or the application which was brought in 2021, we cannot talk of what happened prior to that, or even prior to what happened to our appointment in late 2022. This is when the current NPA team was formed, and we have on several occasions gone out of our way to try and assist parties and to make sure that the matter proceeds. The parties are aware of the fact that the court file has been missing, and in an attempt to recreate the file and reconstruct it, including the annexures, there are certain instances which the NPA has in fact gone to a great deal of effort to do so. On the 31st of January 2024, my colleague and I went to the King Williamstown archives to search the boxes and try and locate these documents. Unfortunately, the boxes were filled with cassettes, and only box 18 contained the judgment, although the court file itself was not present. On the 20th of February 2022, we then went to King Williamstown archives with Mr. Sipho Sumyali from the High Court in Bebeka, and the High Court in Makanda. And he assisted us in going through the archives, including civil records, in order to try and locate the file. Nothing was forthcoming. On the 6th of March 2024, we have made a thorough search with Corey Library to obtain the records. Corey Library is in fact associated with Rhodes University in Makanda. Call numbers were drawn, and unfortunately the record was incomplete. On the 18th of March, we then attempted to make contact with the registrar in Gqeberha as the inquest before Judge Zitzman was heard in this court. Unfortunately, after several attempts to contact her, she has not returned any phone calls, no text messages, no emails. This necessitated us approaching Mr. Kopana directly for assistance in this matter. We first met with him on the 15th of April 2024, when we met in Makanda with Mr. Kopana, Mr. Mpako, and Mr. Somyali regarding the missing court file and further attempts which could be undertaken to obtain same. We then met again with Mr. Kopana and Mr. Mpako after they had completed their search on the 24th of April 2024. There were no further records which were obtained. On the 6th of June 2024, we then met with the registrar again, and we informed him that we were unable to locate the court file despite their attempts, and as such, they should inform the judge who would be assigned to deal with the matter that this is in fact the case. During this time, we were able to obtain a digitized record, which was held by the head of the Corey Library, and he kindly provided same to us, whereupon we commenced sending the inquest and the entire record through to all the parties concerned. We then delivered an index and paginated record to Your Ladyship's offices on the 2nd of August 2024. I'm sorry, my lady, is the matter going to be interpreted? I apologize, I did not inquire at the commencement of the matter.
You can proceed, perhaps we will let the final order be interpreted for the benefit of everyone.
Thank you, my lady.
I hope people have been following what has been happening.
Thank you. All right, our officers have made several meetings with the legal representatives of the family. The DPP has greatly assisted approaching the acting judge president in order to secure a court and to have a judge assigned to the matter. Sorry, my lady. Initially, Judge Potgieter was assigned to deal with the matter, and on the 16th of April, we did advise that unfortunately Judge Potgieter was deeply involved in the TRC matter itself, and as a result he agreed that the matter should be handed over to Your Ladyship. In respect of the persons of interest, apologies, the confirmation of the dates was sent to the acting judge president on the 19th of April 2024, and letters were drafted to the persons of interest dated 27 May 2024. Due to circumstances beyond our control, they were served on the 6th of June 2024. The NPA then continued to prepare for the hearing, having virtual meetings with previous investigating officers during the month of the month of June. And in fact, we had at that stage approached Ms. Hart from the state attorney in order to assist with the covering of the legal costs of the ex-SAPS and ex-SADF members. Apologies. On the 13th of June 2024, Mr. Miller, who unfortunately is not able to attend today, wrote to us regarding his concerns regarding costs and dates. We then received confirmation from Mr. Vasaki, who wrote on behalf of his client, Mr. De Kock, on the 28th of June 2024, wherein he expressed his concern regarding Mr. de Kock's state of health. On the 1st of July 2024, we received correspondence from Jacobs Roos Fisher Inc. for Mr. van der Westhuizen. On the 11th of July 2024, we insisted that a meeting with the presiding officer in respect of this matter must include all legal representatives who have come on record. This was despite Advocate Barney's submissions that it should only be the Families Council and the MPA. On the 18th of July 2024, we had a meeting with Mr. Tito, the head of the State Attorney's offices in Gqeberha, where he provided us with a copy of the state legal representation policy and the procedure which needed to be followed in order to successfully apply for funding. This was forwarded to all the legal representatives on the 19th of July 2024. On the 15th of July 2024, a virtual meeting was held with all the legal representatives, and it was agreed then that the meeting should be scheduled on the 5th of August 2024 with Your Ladyship. During this time, we have had further discussions with Mr. Billet and General Mnisi. Unfortunately, General Mnisi from the SANDF has failed to respond to any of our correspondence or phone calls. In respect of General Billet, he in fact has acknowledged and has indicated that he is dealing with the applications which he has received. Okay. If I could then just take your worship to the fact that the costs of the legal representatives for the ex-members of the police and the army, that is not the only issue which has led to the postponement of this matter. And we maintain that the MPA is in fact in a position to proceed with the hearing. However, it was agreed in the virtual meeting that the matter must be postponed in light of these additional issues which had been raised, mainly being the costs of legal representation. Recently, I received an email from the legal representatives of the families. And in the trailing email, it became apparent that since the 19th of March 2024, Cradock Hoffman had confirmed that they were in fact only representing the Kalata, Mhlauli and Mkhonto families. We requested that they assist us in approaching the Goniwe family in order to attempt to establish whether they would be seeking legal representation. We specifically indicated that Mr. Mbulelo, who we had met with previously, had indicated that he would be looking for legal representation. On the 26th of March 2024, Mr. Sakela confirmed in an email with Cradock Hoffman that he is representing the Goniwe family, specifically Mr. Mbulelo Goniwe, and the Cradock community. In that email, the attorneys for the families, indicated that they will copy him in on all correspondence. Unfortunately, he was never included in any of the correspondence, including on the 24th of June 2024, when Advocate Barney indicated that he did represent the Goniwe children. He made no mention of Mr. Sakela. Further, after again inquiring whether Mr. Mbulelo Goniwe had approached them, a virtual meeting was held with the legal representatives, on the 15th of July 2024, where it was raised that costs was in fact an issue. Again, Cliff Decker-Hofmeyer omitted to mention Mr. Sakele. Then, on the 5th of August 2024, we had a virtual meeting with the presiding officer, Your Ladyship, and all legal representatives were to be included. However, Mr. Sakele was not copied on the link. On the 12th of August 2024, the virtual meeting was held with Your Ladyship, and a draft order was granted. That order now forms part of the rescission application. Mr. Sakele was still omitted from this meeting. I apologize. On the 15th of August 2024, it came to our attention that Mr. Sakele has in fact indicated that he is representing the Goniwe family. He approached the DPP directly in this regard, and we immediately contacted all parties and requested that he be copied in on all correspondence and all virtual meetings from that day. As Your Ladyship is well aware, after Mr. Katobi has has indicated what their problems are in respect of legal fees, this could possibly have been dealt with at the commencement of the discussions between the other legal representatives for the families as well as Mr. Sakele. Unfortunately, the postponement in this matter cannot be laid at the hands of the MPA. We have we have specifically dealt with the families, we have had meetings with the families in the past. We have also had correspondence and interactions with all legal representatives and assisted as best we could to speed up the matter. Unfortunately, as we were unaware of Mr. Sakele's involvement in the matter, we were unable to assist in that regard. My lady, if there's anything further.
No, thank you, Ms. Bosman. I do not, I've not had any of the parties downplaying the role that you have played in trying to assist. But the complaint I hear, which probably is due to the fact that we were only able to trace the full records, the missing files around May or...
Yes, that is one of the main
yes,
main
and the
factors.
complaint that I seem to be getting from the parties is that by June it was too late for the parties, for the witnesses were only informed then, were only subpoenaed then, so it was already too late for the applications relating to legal representation to be dealt with timeously, barring of course the issue of the Goniwe family. I don't think anyone is downplaying the attempts that you made at assisting, but the complaint is that the time by which it became clear that the inquest will be proceeding, or the reopened inquest will be proceeding, did not give enough time for arrangements to be made for legal representation or funding in respect thereof. Am I right?
Sorry, my lady, you just...
Okay.
Thank you, my lady. Unfortunately, as a result of our inquiries to try and locate the record in any form, unfortunately, it did only appear to be available rather late in the matter. We are, however, uncertain if other parties have been able to obtain copies of these documents, as the legal representatives and families have indicated that they have been in possession of the record.
Okay, perhaps in view of the fact that the inquest will not be proceeding today, that's an issue you can deal with at a later stage in preparation for the actual commencement of the reopened inquest.
Thank you, my ladies.
Does that does that lead to the rescission or the postponement?
Milady, if I could just offer some short clarification. Firstly, on the question of the missing court file, I'd like to bring it to the attention of the court that there seems to be something of a trend or pattern of key documents going missing, because it was not just the criminal, at least the court docket, the court file that went missing, but the investigation docket, the criminal docket, went missing in 2013. And my lady, it went missing from the offices of the National Prosecuting Authority in Pretoria. We in fact laid criminal charges in relation to the missing docket. Nothing came of that investigation. In relation to Mr. Imbelela Ganiwe, I don't wish to burden this court with the to and fro that did take place, but my instructions is that he was offered legal representation. He chose to seek independent legal representation, which of course is his right to do so. He was referred to the NPA. The attorneys, Sekela and Corporation, were referred to the NPA in March. From what I understand, my attorneys did provide Mr. Imbelela Ganiwe's attorneys with as much information as was in their possession. But since he was now on record being represented by separate attorneys, the suggestion by the NPA that we were now responsible for quasi-representing Mr. Imbelela Ganiwe when he had his own attorneys is a ridiculous assertion with respect, milady. The NPA should have been in regular contact with those attorneys and not used a middle set of attorneys which were not representing Mr. Imbelela Ganiwe and the community. That responsibility lay with respect with the NPA. Milady, on the question of the record, in our respectful view, the record in its current state is not fit for purpose. I'm not going to go into the details, but we will offer support to the NPA in this regard, and we will, before the next inquest, work with them to ensure that this court is provided with a record upon which the truth can be sought.
Thank you, Mr. Zwane. Shall we move on to the postponement or the review, the rescission first?
Thank you, my lady. Lady, I've just been presented with a proposed draft order, and the state attorney who is sitting to my right just wants to clarify certain of the time periods which I alluded to when we last discussed the matter in chambers. With that in mind, I may need time just to confirm certain of the timelines that have been proposed. I understand that because it also relates to the Solicitor General and the Minister insofar as any appeal process are concerned, there's certain calls that need to be made by the State Attorney before I propose an order in the terms that has been presently prepared. I may just need time to canvass that.
Circulated to other parties.
It has been, but it's subject to certain further inputs, I understand, my lady.
No.
So I may ask for 20 minutes or half an hour of your time, my lady. I do apologize. I would have hoped that the timetable would have been resolved by now.
Does that impact on the postponement, or shall we deal with the postponement? What do the parties feel?
Lady, if I might mention, the draft order deals with the rescission order that your ladyship is requested to make, and then the matter can be postponed after that. I don't know. Sorry, we can deal with the other issues now. I don't know how long it will take, but as far as the postponement is concerned, I think the matter can be postponed. We can deal with this.
Mr. Cradock?
I think so far as the rescission per se is concerned, I do understand that there's no opposition to the application for rescission. In other words, the principal relief can be granted. It's really what follows on the rescission that there perhaps needs to be further engagement. In fact, there needs to be further engagement, not perhaps needs to be.
Anyone against the proposal that we deal with the postponement?
But objection. I just would like to indicate that the dates which have been agreed between the parties are 2 to 20 June 2025.
Mr. Bowman?
Milady, we're also not opposing the rescission, and we don't have an issue with the draft order. Well, I do raise one concern. Milady, I'm sure you don't have a copy of the draft order in your possession.
I do.
Oh, you do. In paragraph...
Oh, sorry, I'm talking about the rescission.
Okay.
Thank you. Yes, Mr. Van.
In paragraph 2, it says that the first to fifth respondents shall make their applications for financial assistance on or before the 30th of September. My understanding is that those applications have already been prepared, or perhaps in the process of being prepared. And do we really need to wait a full month before they submit them? If we can submit them perhaps in the next 14 days, then that might speed things up a little bit.
Okay.
Lady, sorry, I'll just come back to what I alluded to earlier. This is really the timetable as to what is to happen. And maybe the mechanics of that timeline just needs to be further engaged upon. But there's no contention regarding the first prayer, my lady. This is what is to follow. And might we perhaps just have just the next 15 odd minutes just to iron out that timetable, my lady.
Okay.
Thank you.
All right. Shall we deal with the postponement? So that those who are not affected by the order sought to be rescinded can be excused.
The lady certainly brought to my attention that we're not aware of potential witnesses that Mr. Mbeleganiwa's team might wish to call, because currently the schedule has been designed in a manner to deal with the family's witnesses as well as the state's witnesses. Now, if there are additional witnesses that may impact on the number of days needed, so I just placed that on the table.
All right. Should I allow this to also be dealt with during the adjournment? Should we adjourn for this to be? Yes, Mr.
Lady, I suggest my submission is that it is not necessary. I'm sure that between ourselves and Mr. Toby, Mr. Sakela, that can be sorted out.
I was going to suggest, my lady, the proper way to move forward is to rescind the order of the 12th of August 2024, and number 2 is to postpone the matter to the 2nd of June 2025 until 20 June 2025, and no more than that. And then there is a lot of toing and froing on the draft order. I also have clauses I want to add, but that's not going to help us. So we can bring the order to your ladyship in chambers, but there are only 2 orders to be made now: is the rescission and the postponement.
Thank you. Okay, you must have during these proceedings had mention of an application for the rescission of an order that I issued on the 12th of August 2024. This related to legal representation or payment for legal representation of certain parties in the matter, in particular by the South African Police Service and by the South African National Defence Force. Discussions earlier on indicated that the application which Mr. Gada was here to move is not opposed, and to that end, the order that I issued on the 12th of August 2024, directing, as indicated, SANDF and SAPS to provide the necessary authorization in relation to the payment of legal costs for some of the parties requiring such funding is hereby rescinded. And as indicated also earlier, it has become apparent that the proceedings will not be commencing today, and to that end the parties have agreed to a period to which the inquest should be postponed, which is the 2nd of June to the 20th of June next year. Accordingly, the inquest is postponed until that period to commence on the 2nd of June.
wesibini ukuya kumashumi amabini kwinyanga kaJuni kunyaka ka-2025 ozayo. Naye inkundla nomyalelo ewukhuphileyo ngomhla we-12 ka-Agasti sokubana ngaba isebe lezokhuselo nesebe lezamapolisa ligunyazise inhlawulo apho ifaneleke abantu bamahlawulwe khona abameli bezi ntsapho ngokolhlobo bemelwe ngalo. Nkosi.
That the court will adjourn.
Can I